Hello and welcome to the Minimum Competence episode for Thursday, October 16th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have a federal judge blocking Trump's layoffs, a surge in law school applicants, troop pay legal drama, and Norway's smart EV subsidy phase-out. Let's remember, but don't hurry the journey at all. Better if it lasts for years. And read today's legal news.
This is London. Judgment at Nuremberg. Here is John Snagg to introduce recordings made today direct from the BBC studio in the courthouse at Nuremberg.
On October 16, 1946, 10 prominent Nazi war criminals were executed by hanging in the aftermath of the landmark Nuremberg Trials, held to prosecute key figures of the Third Reich for crimes against humanity, war crimes, and crimes against peace. The executions marked the culmination of months of legal proceedings conducted by an international military tribunal composed of judges from the Allied powers: the United States, the United Kingdom, the Soviet Union, and France. Among those hanged was Joachim von Ribbentrop, Hitler's former foreign minister, convicted for his role in orchestrating Nazi foreign policy and enabling the Holocaust. The trials had concluded in late September of 1946, with 12 of the 22 main defendants receiving death sentences. However, Hermann Göring, one of the most high-profile defendants and head of the Luftwaffe, committed suicide by cyanide just hours before his scheduled execution. The hangings took place inside the gymnasium of the Nuremberg Palace of Justice, where the tribunal had convened, and were carried out in the early morning hours. The executions were overseen by U.S. Army personnel, and steps were taken to document them for historical record. The event was viewed by many as a pivotal moment in the establishment of international criminal law, affirming that individuals, even heads of state and high-ranking officials, could be held personally liable for war atrocities. These proceedings laid the groundwork for future tribunals, including those for former Yugoslavia and Rwanda. Some criticized the process as victor's justice, pointing to perceived inconsistencies in sentencing and legal procedures. Nevertheless, the trials represented a significant shift from the post-World War I approach, which had failed to adequately prosecute war crimes. The executions on October 16th symbolized not only the end of an era of unchecked totalitarian violence, but also the beginning of a new international legal order based on accountability and the rule of law. A federal judge in California has temporarily blocked the Trump administration's latest wave of federal layoffs, calling the move likely illegal and in excess of authority. In a sharply worded order, U.S. District Judge Susan Ilston halted terminations that began last week, siding with a coalition of federal worker unions. Ilston criticized the administration's approach as ready, fire, aim, and warned that the human cost of such abrupt cuts is unacceptable. The layoffs, over 4,100 in total, targeted several federal agencies, with the Departments of Health and Human Services and Treasury seeing the bulk of cuts. Judge Ilston's order requires the administration to report all completed and planned layoffs by Friday and set a hearing for preliminary injunctions on October 28th. She also rejected the Department of Justice's attempt to steer the case toward procedural issues, stating that the legal merits were too concerning to ignore. President Trump has framed the cuts as politically motivated, stating they were aimed at eliminating programs he called, quote, egregious, socialist, semi-communist. He added that Republican-backed programs would be spared. The administration recently lifted a long-standing hiring freeze, but is now requiring agencies to submit staffing plans for approval. Union plaintiffs argue that the layoffs violate the Anti-Deficiency Act, which we'll talk about in a little while, and the Administrative Procedure Act, citing the administration's use of the government shutdown as an arbitrary justification. The case, AFGE v. OMB, marks another legal confrontation over workforce reductions, following an earlier freeze issued by Judge Ilston that was ultimately overturned by the Supreme Court. The 2026 U.S. Law School admissions cycle is off to an intense start, with applications up 33% compared to this time last year, according to new data from the Law School Admission Council. This surge follows last year's admissions boom and signals another highly competitive year for aspiring law students. Admissions consultant Mike Spivey, speaking to Reuters, noted he's never seen such a sharp early increase in over 2 decades of reviewing application data, predicting a likely total rise of around 20% once the cycle concludes. Several factors are driving the spike, including a tough job market for recent college graduates, whose unemployment rate now surpasses that of the broader labor force, and growing political instability. Law School Admission Council President Sudha Sethi also cited concerns about the impact of AI and broader economic uncertainty as motivators for many applicants. Additionally, more people are taking the LSAT this year, up nearly 22% over 2025 levels. A recent Kaplan survey found 56% of law school admissions officers pointed to politics as a major factor behind last year's surge, with 90% expecting this cycle to be just as competitive. Some applicants are likely reapplying after being rejected last year or returning after delaying applications due to last year's high volume. While law schools will benefit from a deeper pool of candidates, Spivey warned the sharp increase means tougher odds for acceptance across the board. President Donald Trump's decision to illegally fund military pay during the ongoing government shutdown is only a short-term solution, according to House Speaker Mike Johnson. On Wednesday, Johnson confirmed that 1.3 million active duty service members, along with tens of thousands of National Guard and reservists, were paid using $6.5 billion in unused military research and development funds. However, he warned that unless Democrats act to reopen the government, troops are unlikely to receive their next paycheck on October 31st. The White House has not explained its legal rationale for this funding maneuver, and it hasn't requested the required congressional approvals to shift funds between accounts. Federal law caps such transfers at $8 billion annually and only allows them if the funds are used for their legally designated purposes. Without further funding authority, it's unclear how the administration could cover future military pay. While many lawmakers support a standalone bill to guarantee troop pay, Republican leaders, including Johnson and Senate Majority Whip John Thune, are resisting that option. They argue that doing so would reduce pressure to end the shutdown overall. Some Republicans, like Senator Lisa Murkowski, say the move has reduced urgency in Congress while leaving other federal workers unpaid. The political optics are further complicated by Troop's claim that only Democrat-backed programs are being cut, as he seeks to frame the issue as partisan. Internally, GOP leaders worry that passing targeted funding bills could open the door for broader demands for agency-by-agency funding relief, weakening their leverage in shutdown negotiations. By way of brief background, the move likely violates the Anti-Deficiency Act, or ADA, which bars federal officials from spending money before or beyond congressional appropriations. Trump reportedly ordered the Department of Defense to divert funds from the RDT&E research account, meant for weapons research, to cover military payroll. That account is not legally authorized for such use, and the funds may have also exceeded their availability period. This raises two major legal issues. First, under the Appropriations Clause, which is Article 1, Section 9, Clause 7 of the Constitution, only Congress may authorize government spending. The president cannot repurpose funds without specific legislative approval. Second, the ADA prohibits both misappropriation of purpose, that's spending money on unauthorized functions, and misappropriation of timing, that's using expired funds. If proven willful, such violations can carry criminal penalties, though prosecutions are rare. Beyond the legal breach, this act could set a dangerous precedent. If courts decline to intervene, it could signal that future presidents, regardless of party, can redirect federal funds without congressional consent. This would erode legislative power and potentially turn the presidency into a de facto appropriations authority, undermining the Constitution's separation of powers. And special thanks there to Bobby Kogan, the Senior Director of Federal Budget Policy for the Center for American Progress, for his instructive Blue Sky post explaining the deficiency issue in a way much clearer and more succinctly than I otherwise would have been able to. A link to that post is in the show notes. And finally, a piece I wrote for Forbes this week looks at how Norway is showing the rest of the world how to end EV subsidies, that's electric vehicle subsidies, without wrecking the market. The country announced in its latest budget that it will phase out its long-standing value-added tax, or VAT, exemption for electric vehicles, partially in 2026 and fully by 2027. This might seem like a policy retreat, but the timing is deliberate. EVs now make up 95 to 98% of new car sales in Norway. The market has matured and the subsidy is no longer essential. I argue that this is what smart policy looks like, temporary support that steps aside when it's no longer needed. The U.S., by contrast, killed its federal EV tax credit abruptly and politically, without phasing it out or adapting it for current market conditions. In doing so, it treated the credit as a political symbol rather than a market tool. Norway, on the other hand, used the exemption strategically, aligning it with broader policy goals and allowing it to sunset once those goals were met. The piece highlights how the U.S. often fears both removing and maintaining subsidies, caught in a cycle where incentives become political footballs. Norway's approach offers a model for how to responsibly end subsidies, gradually, rationally, and only once the market no longer needs them. This isn't an anti-EV or anti-climate policy, it's a sign that the original policy worked. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, Lastragonians and Cyclops, angry Poseidon, don't be afraid of them.